All right, good afternoon, everyone. My name is Major Jeremy Gruner, one of the conference organizers and assistant professor here at the United States Air Force Academy. And it is now my honor to introduce our next panel involving international perspectives and coalition space operations. And since the end of World War II and the creation of the modern post-war international order, the United States has relied on its international allies to help preserve international peace and security. Dr. von der Dunk mentioned during his keynote just a few moments ago the concept of the bundle of sticks. And this reminded me of a perfect analogy to kind of introduce this forthcoming panel. As in Aesop's fable of the old man and his sons, or as portrayed in films such as Akira Kurosawa's Ran, on its own, any state, no matter its relative size or its appearance of wealth or strength, can be vulnerable. But together, like the bundle of sticks in the fable or the bundle of arrows in Ran, states can be virtually unbreakable. And this is no less true in the context of space operations than it is in the terrestrial context. And the United States is proud to work with its international partners to ensure that outer space access and use are safe, protected, and characterized by responsible behavior. Our panelists will discuss the critical ways in which the US's international allies contribute to these goals. Our moderator for this panel is Ms. Lynn Tatro, the Senior Space Operations Law and Policy Advisor for Combined Force Space Component Command and Space Operations Command West at Vandenberg Air Force Base, California. Ms. Tatro supervises and provides guidance and professional oversight to assigned and detailed personnel. And as a legal and policy expert for space operations, she provides legal, strategy, and policy guidance to the commander, staff, and various centers. CFSCC is responsible for directing assigned and attached forces in planning, integrating, conducting, and assessing global space operations in order to deliver combat-relevant space capabilities to combatant commands, coalition partners, the joint force, and the nation. Ms. Tatro served as an active duty Air Force judge advocate for 20 years at Wing, Major Command, Headquarters Air Force, and Combatant Command positions. She served as a current operations judge advocate at the Combined Air Operations Center in Al Udeid and at the Air Operations Center in Ramstein, Germany. She also served as the staff judge advocate while deployed at Bagram Air Force Base, Afghanistan, and Manas Air Force Base, Kyrgyzstan. She's admitted to practice law before the Supreme Court of Florida and the Supreme Court of the United States. Ma'am, I'll go ahead and turn the panel over to you. Thank you so much, and the floor is yours.
Thank you very much, Jeremy. I really appreciate the introduction and actually wanted to say good morning, good afternoon, and good evening to all the panelists who are participating today. For some of you, it's an ungodly hour, and we really appreciate your participation. But I'd also like to go back and thank you, Jeremy, and actually the Air Force Academy for your help in hosting the conference. It's been a terrific conference so far. Today's keynote speakers from the U.S. National Security Council perspective, as well as our commercial and Professor von der Dunk, who's always a wealth of information, has really left us, quite frankly, with, I think, more questions than answers. And I suspect our next panel will do so as well. I'm happy to be able to moderate this panel of my friends, quite frankly, and colleagues. And I thank them again for agreeing to participate today in this panel. Now, in my position as the legal advisor for CFSIC, the commander for the Combined Force Space Component Command, we are an operational component of U.S. Space Command. And the legality of military space operations are a regular topic of discussion for our commanders, for our leaders at the national level, as well as our allies and commercial civil partners. And a lot of the discussions that we've heard go on today already are forefront in our conversations that we have with our national leaders, our military leaders, but also with our foreign partners. And so I think that's why today's panel is going to be particularly interesting and helpful. We know that space law, space operations are not readily observable, certainly not well understood by most people in the general population or by the majority of our military and national leaders, for that matter, quite frankly. We're getting better at it as we've stood up U.S. Space Command and U.S. Space Force in the U.S. And so we're seeing this discussion becoming really much more prevalent in just the general population, as well as to what space offers. So our military legal practitioners need to understand not only what is intended, the intended outcome of our military space activities, but how those activities are viewed by others. And one way of achieving that understanding is working closely with our allies and our foreign partners in forums such as the Combined Space Operations Initiative, which we have parties of like-minded nations, kind of military personnel. Many of the attorneys on this panel have worked in that capacity in kind of talking about military space operations and the legal implications of that, and also in conferences like this one. So we all agree, I think, and it's pretty clear that there's a widespread agreement that international law applies to outer space, as clear by Professor von der Dunk's presentation. There are continuing uncertainties, however, regarding the applicability, the scope, and the substance of existing frameworks, legal frameworks in the space domain. This has the potential to give rise to instability in this strategically important environment. I think today's distinguished panel of 5 international lawyers will explore the existing legal frameworks in the space domain. And what's important today is kind of just getting their perspective on where we are in basically the space laws as it applies right now. And so on our panel today, we have Mr. Tom Gregory of the United Kingdom Ministry of Defense, Colonel Rob Holman of the Canadian Armed Forces, Captain Nathan O'Brien of the New Zealand Army, Ms. Svenja Barang of the German Federal Ministry of Defense, and Wing Commander Craig Devaney of the Australian Armed Forces. And all of these, my esteemed colleagues, have their bios are in your conference packets. So I won't go into detail, but what I did think what would be helpful is if they each introduced a little bit about what they do in their current positions and how they deal with space law and operations in their jobs that they currently hold. And so as moderator, I get the prerogative to start, ladies first. I would like to turn it over to Ms. Svenja Barang of Germany and ask if she might tell us, spend a few minutes just telling us a little bit about her position and what she does with regard to space law. Thank you, Svenja.
Thank you very much. Love being the first. And first of all, thank you for organizing that conference. It's really, really interesting. And I guess the first one would really focus on military operations and space law. And thank you for having me. I'm really looking forward to the discussion today. So with my job, I am the Counselor Space Law in the Ministry of Defense, in the German Ministry of Defense. So my job is anything related to space law. I do national space law, I do international space law. I'm part of all our multinational corporations. I do all the exercises and war games. So everything that has any relation to space and law is on my table. So, I do the operative stuff. I do the strategic planning. So being one of very few space lawyers in the German Armed Forces, I'm the one everything goes to. So to every point we're going to discuss today, it's probably have been part of my work in discussing that very deeply, military operations and how space law comes into that, how we deal with it in multinational corporations, having different interpretations of law. Of course, we always say you have 2 lawyers and 3 opinions. So, and yeah, that's what I'm doing. Thank you.
Thank you, Svenja. I really appreciate that. Let me turn it over to Mr. Tom Gregory of the United Kingdom Ministry of Defense and see if Tom can provide us a similar kind of backdrop. Thank you.
Thanks very much, Lynn. And firstly, I'd also like to thank the organisers for putting on this conference and setting such an interesting agenda. And it's a privilege to be part of this event and to be speaking with many of my colleagues and friends who I've got to know over several years in very dark places, in war games and very secretive bunkers. So it's it's nice to see everybody out in the open. So I work for the UK's Government Legal Department, advising ministers and policy and operational colleagues in the UK's Ministry of Defence head office. And that office functions as both a Department of State and a strategic headquarters for military operations. So legal advisors there that I work with and in my team, we can be involved with anything from very, very high level policy formulation, things like the discussions we're having about space in the UN, right down to very specific operational activity. And that's across all domains. The team I work in covers everything from very traditional activity through to novel capabilities. And space obviously is a big part of what we do. And space has been important to the UK for a very long time. The UK was the third nation to operate a satellite. We started out in 1962. And space is a huge growth area for the UK right now. We've seen the development of domestic space launch capabilities, commercial spaceflight opportunities. These all need military advice, legal advice, which tends to come from other departments of government, but there's quite a cross-government effort because we're a small community of lawyers who have particular expertise in space, and we all try and help each other out as best we can. Specifically on the military side, we've recently created a new space directorate within the Ministry of Defence, and our UK Space Command has just been stood up at the start of this month. So there's some exciting things happening there organisationally. And as we've heard, my Foreign Office colleagues are promoting a lot of work on responsible behaviour in space through the UN, and on the military side, we get heavily involved with that too. International partnerships are very important to the UK, not least when it comes to space. We've heard about many of the challenges and opportunities facing us, and we tend to see the solutions as being in collaboration with like-minded partners. So it's great being at events like this where we can share thinking and talk through some of the uncertainties that we're all facing. And I'm very much looking forward to participating in this discussion. And I've got to add the usual caveat that my remarks are personal and shouldn't necessarily be taken as reflecting the UK's formal position on anything, but hopefully we can have a good conversation. Thanks.
Wonderful. Thank you, Tom. I really appreciate that. Let me turn it over now to Colonel Rob Holman of the Canadian Armed Forces and ask that he provide a similar kind of background for our participants.
Thank you, Lynn, and thank you to the Air Force Academy and to Space Command for organizing the conference, particularly Jeff and Jeremy, who have been working with us so hard to make sure that we're all connected properly and so on. And thank you to Lynn for moderating. I should also say thank you for the opportunity to put on a more formal uniform for, I think, only the second time in the past year. And frankly, the last time was speaking on another panel that Lynn moderated, where Franz von der Dunk and I spoke at the Naval War College. It's a nice change, and it frankly does me a little bit of good to see that it still fits. I'm not going to talk about my current job, because my current job is as Chief of Staff of the Office of the JAG in Canada, and so my connection with space legal advice these days is really more related to ensuring that the folks who are given that job are properly resourced to do it. But until this past summer, I was for 3 years the Deputy Judge Advocate General of the Canadian Forces for operational and international law. And in that context, I was responsible for the provision of all legal advice for all Canadian Forces operations, and that included space operations. Given my background with a master's degree in air and space law, I did take a particular interest in space law, and so was involved in the CSPO processes as a Canadian representative, and in fact was the chair of the CSPO Policy and Legal Working Group for a year on behalf of Canada. But I guess most relevantly, I am part of the WMRA manual process, which Professor von der Dunk introduced. In fact, the backdrop behind me, if you see it properly, is the public gardens in WMRA, South Australia. which doesn't consist of too many trees. Actually, it shows a few trees there, but an awful lot of rockets and uninhabited aerial vehicles and so on that were tested on the Woomera Range. And as part of the Woomera project, for now getting on, if you count the predecessor involvement I had in the Malamos project as well, getting on to 5 years, have been very and continue to be very involved in trying to put together a useful document for military space operators and military space legal practitioners, and frankly for the broader space law community. And I'll be happy to talk about that a little bit during some of my other remarks. Thanks.
Fantastic. Thank you very much, Rob. I appreciate that. Now, if I can ask Captain Nathan O'Brien from the New Zealand Army, see if he's got a few words he'd like to say about his current position and kind of how he interacts in space law.
Kia ora. Good morning from New Zealand, and thank you. First of all, I'm very honoured to be a part of this discussion. And a big thanks to US Space Command and the Air Force Academy for putting this on. My background is as a lawyer for the New Zealand Defence Force, a legal advisor, predominantly at the operational level. My current appointment is the Assistant Director of Operations Law, which in part, and only in part, sadly, includes advising the NZDF representatives on CSPO, or the Combined Space Operations Initiative. And part of that role is also getting to liaise with lawyers from other government agencies, our Ministry of Foreign Affairs and Trade, and with their space lawyers. So I get to soak from their brains as well. I've been in a role for only about 9 months. So much like New Zealand's space industry itself, I'm comparatively new on the scene, but I'm nevertheless very excited to be involved in the discussion.
Great. Thank you very much, Nathan. Appreciate that. And then last but certainly not least, Wing Commander Craig Devaney of the Australian Armed Forces. If you could give us just a few words on your participation in space law development in Australia, that'd be great.
Sure, thanks, Lynn. And good morning to everyone as day breaks here in Australia. Certainly, the conference has been great so far. It's meant for some very early mornings, but I've enjoyed the sessions I've been able to attend. Look, my current role is in the Operations and International Law Directorate of the Military Law Branch in Department of Defence in Australia. Our office is a strategic level source of advice across many different portfolios. Space is but one of those portfolio areas that I have responsibility for at the strategic level, in addition to cyber, weapons reviews, air law, and a range of other topics. In that capacity, there's a range of interagency or interdepartmental liaison that goes on, as well as working across the three armed services in Australia. Importantly, of note, recently folks are probably aware that the Australian Air Force has been assigned responsibility for the space domain and has a dedicated space law position as well. So that's currently filled by Diana Dombrovska. And I'd like to provide a quick shout out to the USAF Major, Chris Bailey, as well, who's also attending and listening to this presentation of my office, who's done some great work in the area of space law and policy discussions. My background in some of the different space war games and initiatives goes back to 2009, 2010 with some early war game involvement and a number of different involvement sessions with CSPO and so on. The conference, I'd like to thank yourself for putting this on, and thanks, Lynn, for hosting this panel. My observations at the sort of outset would be that it's significant in terms of timing as we all start to stand up and look at different command and control arrangements for space and military operations, and it's also symbolic as we look to strengthen our alliances and partnerships both in the space domain and in a more general return to multilateral activities, whether that's in the maritime or air domain, and some other broader discussions on law reform and lawmaking in terms of the cyber domain, and looking at additional discussions about treaty law or the creation of norms and responsible behaviours. So all of those topics you'll see referenced in recent strategic updates from Australia and force structure review documents that folks attending the conference might be interested in. At that, I'll leave my remarks there and look forward to the forthcoming discussion.
Super. Thank you very much, Craig. I appreciate that. And thank you to all the panelists, quite frankly, for your introduction. I think you give a lot more justice to the incredible amount of work and diversity of work that you all are doing in your various countries and governments. I'm always impressed every time we get together at how smart you all are, and at just what a robust conversation that you bring to the topics. And so I won't delay any further. I will note that beginning our conversation now, we have approximately an hour and a half to discuss some topics. And if this panel goes like any of the ones earlier today, I'm sure we'll have tons of comments from the participants of the conference. So I would like to note that basically during this morning's keynote, the National Security Council from the US perspective and the DoD Commercial Partnership panel, as well as Professor Vonderdunk's presentation, were all quite clear in outlining that the space domain has changed very much over the last 50-something years since the Outer Space Treaty went into effect. And as strategic and operational level defense attorneys practicing space law, we've all fielded the questions about the utility of the Outer Space Treaty and its applicability to military space operations. From your personal perspectives, I would like to ask if you think that the Outer Space Treaty is outdated. I know there's various opinions out there, and do you think that we need a new legal regime in order to effectively operate in this wildly changing environment? I think it's an important question that everyone seems to be getting asked these days, and so your perspective would be appreciated. So let me start this time with Tom Gregory, if I could, please.
Thanks, Lynn. And as you know, it's a favourite topic of mine whether the Outer Space Treaty is a truly outdated relic of the past or still has some kind of relevance to us today. And I think the answer lies partly in what you expect the Outer Space Treaty to do. If you're looking for highly detailed prescriptive regulation, I think you're going to be disappointed. But if you view the Outer Space Treaty as one part of a broader international legal regime that governs relationships between states, you'll possibly reach a different conclusion and see it in a different light. And as Dr. Howard said yesterday, the OST is mostly a treaty of general principles. So my perspective is, I think despite what some people might suggest, I really think we have a lot of legal tools already for addressing space-related activity from a military and national security perspective. And importantly, when you consider those tools in aggregate, including the Outer Space Treaty, I think there are relevant and useful provisions that help guide how we can handle hostile activity, as well as framing how we can go about our own proactive operations. Now, that's not to say we've got all the answers and everything's perfect. Clearly, space raises some difficult issues, and Professor Vonderdank outlined those superbly, and there's plenty more to consider. But I think it is worth bearing in mind that we don't have specific answers for every possible situation in other domains. And we manage without jumping to a conclusion that the law is inherently flawed, it's fundamentally lacking. We work hard and we work with what we have. And cyberspace is quite an interesting comparison here because we don't have the treaties in the way we do for space. But I don't think we see it in quite the same suggestions that we've got inherent problematic gaps in the law for cyber that we sometimes see for space. There's more focus on applying what we have, although there's obviously a lot of debate about how the law applies for cyber. Now, as we all know, the Outer Space Treaty entered into force in 1967. It's been a guiding framework for more than 50 years, but I truly don't think its age necessarily means it's no longer fit for purpose, or space as a whole is lacking some kind of vital regulation from a national security point of view. And I've got three main reasons for saying that. And firstly, just because states haven't publicly invoked or referenced specific provisions of space law when commenting on others' behaviour, it doesn't mean they couldn't. There's a choice to be made. And Ken Hodgkins covered brilliantly some of the reasons for this in the Q&A of the earlier panel. And one of the things I just flag again is that there are many different factors that go into determining whether to publicly attribute hostile activity. And if you're making public statements, whether to allege breaches of international law, many announcements make no reference to law, and there are good diplomatic and political reasons for that. Very often the outcome sought doesn't require a special legal basis to achieve it. So reference to the law in those situations might not be helpful. It might be inflammatory and not really serve your purpose, even if you think there may have been a legal breach behind the issue that you've got a particular concern with. And secondly, I think if the circumstances were serious enough, there is more we can make of existing provisions, including the Outer Space Treaty. And it sometimes takes serious incidents to shed light on how we think international law that we already have works in practice. And it's an extreme example, but how the international community approached the law of self-defense following September the 11th shows how we took existing customary law and made it work for a scenario that nobody had really foreseen, but it worked in that case. And we've seen it develop from there. So far as the Outer Space Treaty is concerned, I think it's possible in the right circumstances that a state might want to make more of its provisions. Say Article 9 is probably the best example, the provisions about due regard. There could be some mileage in that, but that's based on existing law. It's nothing new. It's also worth noting here that I think there are several provisions of the OST that are doing their jobs very well as we speak. There's important provisions around arms control so far as weapons of mass destruction are concerned, and they're as relevant today as they ever were. So that there's a lot in that too. And my final point, which I think is my most important point, is the Outer Space Treaty really isn't the only lens through which to view military and national security space activity. We need to bear in mind the full suite of international law that's relevant, and Professor von der Dunk outlined various aspects of that. And I think if you just take Article 3 of the Outer Space Treaty, it really demonstrates the OST was never intended to do all the heavy lifting for some of these principles. It requires parties to use space in accordance with international law, including the UN Charter, and that probably reflects customary international law now in any event. So we have got a significant body of law that regulates relationships between states. It includes various thresholds for internationally wrongful acts. It outlines the boundaries of response options. And that already applies to space, just as it does to other domains. There's obviously very difficult questions, but it does apply. And so when I'm advising colleagues and I ask what it is they want to achieve, if they're at the more extreme end of the spectrum for some reason, thinking about using force, I'm not looking for a legal basis under the Outer Space Treaty. I'm probably in the territory of the customary international law of self-defense. So I'd suggest that we have the tools, they're just found somewhere else in some cases. And very often it depends on whether there's the political need or will to use them to their full extent. And of course, we've had a lot of unfriendly behaviour that's been tolerated for many years in other domains between states. It's nothing new that we don't all get along in a perfect fashion. And espionage is a fact of international relations and generally seen as internationally lawful activity, even if domestic law might regulate it in a different way. And I think that's all in important context. And it all leads me to say, I think it's best not to view space in isolation, whether that's legally, politically, or practically. That risks some misleading outcomes. Activities in space are clearly related to a broader picture. I'd suggest we have a variety of legal tools at our disposal, and we just need to keep them all in mind and make sure we're testing them, what we already have, as best we can, and that'll help shed light on maybe where there are gaps or where we need to develop things and have further discussions. I think colleagues on the panel probably want to say more about those areas, so I'll stop there. Thanks.
Great, thank you very much, Tom. I appreciate that. Let me turn it over to Colonel Holman and ask him what perspectives he might provide with his experience.
One of my first ones is it's always a good idea not to disagree with Tom Gregory, and so I agree with a lot of what Tom said. The perspective I'd start with is, as an operational legal advisor, as a military space law advisor, I feel like there is more than enough law available to me to do my job, to advise my client. And obviously part of that is law that comes from the Outer Space Treaty. And as Tom has really well pointed out, there's a lot of existing, more general international law that that is applicable and useful. I think one of the reasons behind this issue, the general issue of do we need more law, or do we just need to understand the law that we have better, comes from some siloing in the space law community. Really, until recently, from my perspective, and certainly this is the case in Canada, there's been very little interplay, discussion between those, the community of non-governmental space lawyers, for lack of a better term, those that are focused on more on the civilian uses of outer space, and military and governmental, more operationally focused legal advisors supporting military space operations. And so, in the same way that the Professor Vanderdonk was talking about how the Outer Space Treaty and most of the body of existing international space law was developed in a time when the sort of operations in space, not just military, but civilian, were not contemplated by those who were arriving at the constitutional documents of international space law. In a similar way, the interpretation and the discussion of those has, for the most part, taken place without the same degree of involvement of military or governmental lawyers, and that I think is changing. The fact that we're having a widespread discussion today with a huge spectrum of space legal practitioners and academics participating is an indication of that. I think the expert manual processes, which I'll talk about in a minute, are part of that as well. But the question is, just because we've got enough law, that doesn't mean that it's perfect and that every answer is absolutely clear. There are a number of things that need interpretation, and again, Franz did a very good job, I think, of identifying some of those, and some of those have come up, collaterally during Tom's discussion. Harmful interference and due regard. What are those? What are the meanings of those provisions? Again, states have their reasons for commenting or not commenting in these areas, but from to use a timely space example, how close is too close an approach from by one state's satellite to another state's satellite? What constitutes their harmful interference, lack of due regard? How do you make those pieces fit within the freedom of exploration and freedom of use of outer space principles? Some of that we're seeing now in the civilian space industry with on-orbit servicing and active debris removal technologies. And so there's going to be a useful, and there is a useful and worthwhile discussion there, but one that I think military practitioners should be playing a role in as well. And with every statement that a government makes in respect of these incidents, that has a normative effect, that has a law-making effect potentially. So, is it notable, for instance, that that ASAT tests that have caused debris in recent years, that there has been very little, in fact, if any, reaction from states that have referred to the principles related to harmful interference, for instance, in Article 9. As Tom said, broader international law, I think, is of particular interest here, as it is in cyber, for instance. The meat and potatoes of what is being done in military space, in cyber, probably is in that spot on the spectrum that counts as unfriendly or competitive, depending on where you are, but is certainly below the threshold of armed conflict, and has generally been seen to be below the threshold of threats or uses of force as far as the jus ad bellum is concerned. But for military lawyers, this is an interesting space to be in. You know, when I went through law school and came up as a military lawyer, the jus ad bellum was really not something that military lawyers thought about all that much. The issue, you know, those things were dealt with by Foreign Office or Foreign Affairs lawyers. But now we do have to actually think about, in the space environment, how do we apply some of those principles in a tactical way, as opposed to in a, you know, large muscle movement, state to state way. So what activities in outer space, you know, might, as you move up that spectrum from interference, harmful interference, and so on, you know, what activities might constitute an intervention prohibited by international law? You know, what might constitute a threat of force and a use of force? And I'm grateful to the questioner, to Professor Vanderdunk, because I allowed me to cross out some of the things that I was going to say, and avoids me having to say that I disagree with him necessarily with respect to his views with respect to the applicability of Article 2.4. You know, how does Article 6 of the Outer Space Treaty, which creates a unique responsibility regime for outer space, apply in the military context, and particularly in the context of non-state actors? For those that are planning military operations, you know, what are the sort of connecting factors between a space object and a state that might give rise to, you know, to legal rights of response? So the issues, I think, are really about, you know, the interpretation as opposed to there being a lack of law. You know, these are all issues, and there are many more that are capable of legal debate, on which reasonable people and reasonable states may disagree. So from a public policy perspective, you know, I think what's most desirable is that there be a clear framework for discussion and some venues for that discussion. And so in that respect, let me talk a little bit about the WMRA manual process just for a couple of minutes. You know, without wanting to exclude any discussion of some other valuable processes that are going on in the sort of sub-legal space as well. You know, UN processes, including, I think, the very valuable discussion set off by the UK's recent General Assembly resolution on norms in outer space. But processes like the WMRA manual process, which is made up of practitioners, military and governmental, of academics. And I should say, as I've scrolled down the list of attendees, I'm happy to see at least a dozen of my colleagues from that process who are attending, and I'm really grateful to see that they're here and participating. But what they're intended to do, I think, you know, needs to be clear. There's no intention to make new law. The intention is to identify areas where more discussion, more interpretation may be important, and to really frame the boundaries of debate in those areas. To note where there are significant disagreements, where there are reasonable differing views on the interpretation of some of the issues I've raised, and more, and to set a framework for discussion and debate. You know, none of these processes make law. It's governments that make law, states that make law, and I guess my closing point would be that that processes like this, or like WMRA, processes like the General Assembly processes, are ones where states have, I think, significant scope to influence the creation of more binding law through both their activities and what they say about those activities. And I think there's a huge amount of space in customary international law and in the formation of customary international law, where states who have an interest can start to fill that space. And I think that that's happening, in the context of entities like CISPO, or efforts, initiatives like CISPO, and statements made by the member states in that and in other groups. And I think I will stop there. Thank you.
Yeah, I think that's a great perspective, and obviously the discussion and interpretation part is where we as attorneys and government attorneys help our senior leaders in understanding what the pros and cons of which way we may go in that interpretation. Let me turn it over to Captain O'Brien and allow him to provide his comments at this point.
Thanks, Lynn. I guess first I'd say I would echo Mr. Gregory's comment on assessing the OST and the need to consider what is the expectation or purpose of the OST in determining whether it is fit for purpose. I think that really resonates. Also, Colonel Hoffman's comments around the distinction of operational lawyers and what we do. In my experience, I very rarely have ever sought or looked to develop new law or replace existing law. It's really trying to figure out how to operationalize existing law or principles to address immediate problems, and also considering how those principles may apply for future operations or for the development of future capabilities. And for my time currently as a lawyer, I seem to spend a very large chunk of time trying to understand the technical aspects of cyber and space and intelligence collection, more so than I would be studying law and treaties and precedents, which is, I think, a reflection of the role of an operational lawyer. But I can also offer a bit of perspective, I guess, from myself or from New Zealand on the OST more generally. And that's that the Outer Space Treaty provides the framework, the international legal framework for all activities in space. It provides core principles that remain of key relevance today, and that's particularly so given the magnitude and the complexity of space activities. And I think there's three areas where the OST really provides some benefits and strengths. And this really does echo what Tom said earlier. And the first one would be that the OST provides a number of hard edges for regulating state behaviour, which has been successful. And obviously this includes the prohibition on nuclear weapons in space, weapons of mass destruction, prohibition on the establishment of military bases, the testing of any weapon or military manoeuvres on celestial bodies, the requirement for consultation if it's believed activities may cause harmful interference with the activities of another state, and also that the moon and celestial bodies shall be exclusively used for peaceful purposes. I would argue that all these prohibitions have been relatively successful. And of course, the OST also positively affirms that international law applies in space, including the UN Charter, the rules on use of force, self-defense, and in general, the international collective security system. And I would say New Zealand would accept that international humanitarian law applies during any armed conflict that touches on the space domain, but noting that the desire of the OST is to avoid conflict in space and to reserve the exploration and use of space for peaceful purposes. Together, this allows or permits the application of a military lens to be applied to problem sets in space. It allows states can look to their militaries to assist in maintaining the space environment as safe, sustainable, and peaceful. However, the OST, I'd speculate the OST was negotiated at a time where states may not have foreseen the magnitude and complexity of space-based activities and capabilities that have developed in the last 50 years. And what I'll argue or advocate for is, or what I would say is needed, is further work on understanding across nations on how to give effect and operationalize the principles in the OST to modern space operations and capabilities, rather than looking to create new law, so to speak.
Great, thank you so much for your perspective from New Zealand. I think that the discussion of that expanding interpretation is an important concept as we look at the Outer Space Treaty and our operations as they've changed, space operations for military as well as for commercial and civil, and what's happening in a large part learning to get along together, I guess, in that domain. Let me turn it over to Svenja Bereng and see what comments that she might like to add. Thank you.
Thank you. Like all of my speakers before me, I can only echo what was already said before. I don't think that we need a new legally binding instrument for military operations in space. We do have the Outer Space Treaty. We do have general international law, which gives us a variety of tools to deal with military operations, to deal with threats, to deal with hostile activities, to deal with irresponsible behavior in space. These instruments are out there, and not only from general international law, but especially in the Outer Space Treaty. And looking at my day-to-day job, it tends to be that sometimes from operators' perspective, there's a stunning lack of knowledge about those tools we already have at hand. Just looking at consultations, that's not a one-way street. If you are the victim state, you could ask or demand consultations, especially every state or every member of the OST could demand consultations if it sees something that it seems to be responsible. If you look at inspections, which seems to be new to a lot of people, that there is a rule in the Outer Space Treaty about inspections. We just need to apply it and bring it to life. Not saying that interpretation of these terms like due regard and harmful interference is very difficult. Because we have a lack of precedence in state practice about those stuff, about consultations, about what is due regard. Looking at, is the creation of debris a part of a due regard principle? There are states out there who negate that. So there is a lack of state practice. There's a lack of, and we as lawyers need to fill that with life and bring it to life and make those precedents by just applying the Outer Space Treaty. And then operators tend to go to places they know. So they go to places they have already applied, like looking at cyber law, looking at air law, looking at sea law. So what are we doing there? That was my day-to-day job before I got into space. So just apply that, like not really new, but something that comes up all the time when talking with someone about what we could do to secure our satellites. And now with the Artemis Accords, that again is coming up, is air defense coordination lines or air defense communication lines in space. So having a safety zone around your satellite. I mean, that's an intriguing thought, because that would make it so much easier to just say 5 kilometers around my satellite, if you cross that line, you are hostile, or you have to talk to me. And if you don't talk to me, you are hostile for me. That would make my job so easy. But I don't think that in space it is that easy, unfortunately, because we have the non-appropriation rule. Is a safety zone appropriation? Because I do not exclude necessarily someone going there, but I do not allow it to him, or I declare him hostile. I take away a right he has, the free use of outer space, by declaring a safety zone. Is that appropriation? Or is it not? I guess that's a really fine line, how you make up that safety zone. And then do you overburden the obligation for consultation by doing that safety zones, because you're not only demanding them, but yeah, putting very much pressure on having consultations from someone just, again, using its right for the free use of outer space. And these are all questions we have to take into account. And it's sometimes hard to explain to someone not being a lawyer that I can't give them any specificities. It's a case-by-case decision. And it's a really fine lines when it comes to space law because of that lack of strong interpretations like we have them in other domains already. But I still think that we have to do that. We have done it in all the other domains. We have gone a long way and we'll still have a long way before us. But there are rules and we just have to apply them, which will make that way so much easier. And what Rob said about Rumera and also Milamos, they will probably help us a lot just to see what kind of interpretations are out there. What can I work with? What can I borrow? Which ideas can I borrow from that? And I'm really looking forward to read those manuals. So that's my perspective on it.
Thank you very much, Svenja. I think your points are well taken with regard to the lacking of state practice. I mean, it's really hard to give your military leaders kind of some guidance or interpretation when there's not a lot of practice out there to use as a basis from. And so to your point, yeah, we do tend to navigate or gravitate toward that which we know, which are the other domains. But as you've pointed out, it's not an easy one-for-one kind of an analysis in the legal realm to say, oh yeah, what applies in the air domain and what applies in the maritime domain are easily applicable to space. So I think it kind of goes to Professor Vonderdunk's slide where he shows the big giant question mark in the middle. So what does apply? And so I think that's a great picture of sort of where we are right now in some of this gap. And so until we get more state practice, we're kind of missing some of that aspect of it. So I will go to Wing Commander Devaney to see what input that you might have on this topic.
Thanks, Lynn. Unsurprisingly, I think for everyone, I'm going to violently agree with all of my fellow panelists in the most general sense, at least, to say that really the first step in trying to decide whether the existing laws that we have are appropriate or out of date, it actually ought to involve a more robust analysis of those laws and a more deliberate practice of application and unpicking exactly what we mean when we talk about the application of the existing legal regimes, whether general international law ad bellum, whether specific IHL for armed conflict, and the very specific space law treaties to military operations broadly, and to understand what we mean when we say military operations. Because if we are simply talking about anything that militaries do across what we in Australia would call the sort of competition spectrum or conflict spectrum from cooperation, as we'll get on to discuss, I think, in the second part of this panel with coalition operations, but through competition and times of contest or conflict, I think oftentimes the call for the fact that the Outer Space Treaty is out of date might simply be really something tugging at us to say it's difficult applying laws to behaviour and conduct below threshold of armed conflict, and that's what we're sort of grappling with across multiple domains with various state actors and non-state actors. So whether the call for sort of new legal regimes or more robust legal regimes is a substitute for the lack of other hard policy discussions and whole of government discussions or interagency discussions about what is happening, how we view conduct and behaviour, and where we think we ought to be from a commercial, civil and military perspective. I think all of that really becomes relevant when we start looking at the Outer Space Treaty more generally. In terms of analogues from other domains and other bodies of work that are ongoing, you can see some corners calling for new treaty law with respect, for instance, to lethal autonomous weapon systems, some calls for treaties to be made in the context of cyber activities, but even in those different domain contexts, I think there's a broader discussion around ethics and public policy and government policy that ought lead the discussion, rather than necessarily having very precise military law discussions dominate the conversation, because after all, the military actions and military activities are only one arm of government, and we have a very precise sort of role to play. So in the cyber context, for instance, people might be familiar with the fact that the various bodies under UN auspices have looked at criminality, have looked at development goals, have looked at human rights, not just looked at the application of IHL or in bello laws to cyber action during armed conflict. So I think it's important to have a much wider ranging discussion about what we mean when we say the Outer Space Treaty might be out of date. A couple of other general points before I'd like to make some remarks about responsible behaviours and the question that often gets posed in that context about response options. How do we deal with things that we don't like? I think one of the comments I'd like to make up front, though, is I've seen reference both throughout the conference and in other public discussions to space being the wild, wild west, and there being a lack of rules and guidelines and so forth. I think Professor Vonderdunk's presentation did a good job at identifying the amount of law that's available for all of us to discuss across various spectrums of military operation. Certainly lots of questions, and both Tom and Kel Holman and Svenja and Nathan, everyone has highlighted the fact that there's a lot of work to be done in understanding and applying the existing law. So I think this notion that there's a lack of law, a lack of governance and guidance in terms of what we might do, really doesn't give credit to the work that has been done to date. In terms of some of the other discussions about silos, and we have this discussion in a space law conference about the Outer Space Treaty, but the formation of laws in other domains and the formation of norms and sort of opt-in protocols or non-binding instruments, as I've indicated, is happening across multiple different domains over the past 5 or 10 years even. If you look in the maritime domain and the Code for Unplanned Encounters at Sea, or if you look in the air domain for certainly in the ASEAN, among ASEAN nations with the Guide for Air Military Encounters, there's been a range of different instruments tried to be put in place to increase predictability and to sort of regulate or regularise interactions of militaries in those domains. Not all directly transferable to space, but all building on existing bodies of whether it's law of the sea or international air law, such that it is in relation to military or state aircraft. They provide good examples where we can say, look, we need to be looking at multi-domain operations. We need to understand joint fires and the joint fight and the coalition fight as well. So we can have recourse to some of those different examples. In terms of the space-specific analogues that are often given and drawn from cyber. You know, we've seen the Talon manual come out, and we see the two Woomera and Millamos projects hopefully nearing completion. And like Svenja, I look forward to reading those manuals myself as well. You know, from the cyber context, the recent work of groups of government experts and open-ended working groups under the UN, looking at their previously 11 agreed norms of behaviour, might similarly provide us a good place to start to look at, well, what are different models? Where is the political appetite or the policy appetite for having discussions about state behaviour and regulating state behaviour and guiding responses from states? Because often the question that comes up, and I'm talking to folks on the panel who've had this question many times, I'm sure, what are my response options? What can I do when I see something that I don't like? And they're often asked in those very general terms, as operators are fair and ought to ask. We then try and translate that into legal options and legal solutions, and that's part of the challenge that we have. But in looking at what those norms might do, or what non-binding instruments might achieve, I think we have to be clear about what they are as well, in terms of whether they are in fact new law or not. And in the cyber context, it's very clear that those norms are, you know, reflective of expectations and standards, and they help are intended to help assess conduct, but they're not enforceable, and they are not things that give rise to definite legal response options. So if we're looking at updating, you know, our legal framework by reference to those things, I think we have to be very clear about the basis on which we're working to begin with. I think I might leave my comments there and let some of the other panelists comment as well.
Fantastic. Thank you very much. I think one of the key things that you're talking about is really kind of a focus of one of the earlier presenters during the commercial panel, which was talking about sort of that predictability and transparency, are two efforts that we want to get at when we're talking about, like, what would be the right response option and what would be the right, you know, activities that we would deem responsible or irresponsible. And those are two areas of focus, I think. Let me see if there's any of the other panelists that would like to comment on those areas. So I think the difficulty I think we see certainly in relation to the work being done right now in response to the UN work is that a lot of our nations don't have their determinations yet made as far as exactly what the position will be. And so that creates a kind of an area of discussion that may be a little bit more difficult. So let me go see, before we move on to a second question that I have to the panel, let me take a couple questions that are out there in the Q&A section, which is basically one of the participants is asking, would any of the panelists care to comment on the need for technical standards to evolve the efficacy of existing regimes and the process for standard setting, such as, like in the US, the domestic guidance provided by our Federal Communications Commission, perhaps the standards put forth by the ITU or the International Standards Organization, and see if certainly in the area, according to the commercial panel, there was a discussion of a need for rules of the road and how those might evolve, certainly based on, if not the military, then perhaps commercial and civil space actors, and see if any of the panelists would like to take on that question.
Thanks, Lynn. I'll make a couple of observations on that. I think that there must be something beneficial about things that contribute to transparency, safety, predictability, that sort of best practice, as Ken Hodgkins mentioned in the earlier session. And I suspect developing shared understanding of those types of things is probably easier for states to do than to jump to very prescriptive rules about use of force and things like that. So I suspect there's a lot of mileage in starting out with those types of things, and probably practically very useful beyond the military sphere as well.
Great, thanks. Over to Craig. You look like you might have some additional comments.
Yeah, Lynn, I agree with Tom. I think certainly outside of conflict and focusing on civil and commercial matters, those interests, at least from my perspective, seem to probably originate predominantly in matters of safety and security, and so therefore I think being able to technically regulate and guide those activities is important. Even if it's simply from I then put my military legal advisor's hat on to say, well, that assists in understanding as a technical matter what might be occurring and where that sits within agreed rules or guidelines, because that then is one part of understanding conduct in or affecting space activities. So the technical understanding and the operational impact then starts to feed in essentially the facts for a legal analysis. So I think those things are probably easier agreed, as Tom said, and a good places to start. A bit like focusing on criminal misuse of cyber infrastructure and cyber domain becomes a lot easier for states to look at and talk about with sort of shared understandings before getting into the issues of military uses of force.
Thanks. Colonel Holman, over to you.
Yeah, I think Dev touched upon the point I was going to make at the end. Anything that narrows the range of uncertainty between states, I think is beneficial. So technical standards that define to some extent, what is acceptable and normal behavior, to the extent that they limit what states might otherwise seek to do, at least again gives you a standard of which or against which you can measure things like, is this an unfriendly act? How unfriendly is the act? And so on. To pick up on one of the points that Svenja made about zones, for instance. I think she's exactly right that it's very challenging to define in the space context something that has been developed in the maritime context, for instance, or in some cases might be seen as analogous to to some elements of land warfare. But if there was a technical standard regarding, communication equipment required, things of that nature, in respect of close approaches between space objects, that again gives you something that can start a discussion that will certainly have a normative character to it, and may at some point, have a law-making character to it, depending on how states choose to address it.
Svenja, let me go ahead and let you make some comments.
From my point of view, technical understanding is a really good starting point, and technical regulation is a really good starting point, as Rob said. But if we look at the rapid pace of technical development we have in space right now, I don't think that we get very far with that. We need a technical understanding, and technical devices like communication or things like that are really good and really helpful in the beginning to start. But I guess it's more on the side to use them, to use communication devices, not just have them, to use to just be transparent of what you're doing and using communication for that. is much more important to actually assess if a behavior is irresponsible or not normal, much more than any technical norms we could have, because they will change very quickly. If you look, for example, at like the example I had with how close is too close, what will be my safety zone, that is different for every satellite already. So every satellite has a different zone where he can maneuver in, or if he could maneuver at all, that will again change its safety zone, or what he perceives as being too close, if he could maneuver at all, if he could easily maneuver, or it's just very problematic to maneuver. That already changes the technical parameters. And then we have all those unknown things in space that we hardly know what technical standards does that satellite actually have. What can he do? What kind of satellite is it? How is it used? If he has a laser or any device on it, how could that device being used? So technical standards are a good beginning, and we need that technical understanding. We need a very, unlike in other domains, I always have the feeling as a lawyer, I need a much deeper technical understanding to provide any legal advice, but that could just be the starting point. We need more than that to actually have a helpful assessment of what is irresponsible, what is threatening, what will be hostile.
Yeah, and I think to some extent that technical information that we find helpful in making this interpretation is part of that call for additional transparency. Right now, we don't have a lot of rules and requirements for transparency. We don't know a lot of the particular capabilities, right? Because certainly the current legal regime for registration of satellites is it's very anemic in the area. That just not a lot of information is required. And as governments and military, do we want to have a more robust requirement? Sure, it'd be great to know what the other countries have on their satellites and their capabilities, but would we be willing to also give up that same level of detail and information about capabilities? Which kind of brings us to one of the questions of the participants, which is, should the current conversations involving space laws and norms be proactive or reactive? I mean, where are we trying to go with responsible behaviors? Is it to establish something by which we can judge the actions of others? Or is it something to help us to better understand and avoid miscalculations and misperceptions? Anyone have any comments on those kind of questions? Svenja?
I'm a big fan of being proactive and taking back the narrative. So for me, rules of behavior are in the first place a means to avoid misperceptions and miscalculation and misinterpretation in the future with our operations, rather than calling out someone for its behavior. That's a good thing. That's helpful as well. But in the first instance, responsible behaviors for me are a means of avoiding just escalation in space by misinterpretation.
Yeah, good points. Is there anybody else on the panel that would like to comment at this particular point about responsible behaviors? If not, I will go ahead and move on.
Lynn, I'll just make a very quick comment. I think the question's a good one. I think that the proactive approach to lawmaking requires a very strong policy foundation and broader discussions outside the law. So if legal advisors are having those conversations, I think it's very important to be quite clear about whether they're providing legal advice and explaining the consequences legally of what's being proposed, as compared to having broader discussions about what should or ought to be done from a sort of policy perspective. Of course, the international law generally has typically developed in a reactive sense, with some notable exceptions. NMOD being one of them. The debate currently in the laws context in terms of looking at proactively addressing concepts or concerns or risks and threats. They're two different examples of proactive style discussions about lawmaking and regulation. But I think what's sitting behind that question is a requirement for a strong policy-led discussion first.
Yeah, and I think that's fair. And one of our participants actually, brought that up in a question in the Q&A session. Isn't whether a new treaty is needed a political question as opposed to a legal one? I think the legal application of this, or the implications, really is, where we as government practitioners in space law able to provide, is there enough robust meat to the current legal regime to be able to provide guidance to our leaders and our bosses in that area. So, yeah, it's a good question, and I think there's a big part of it that has a lot of political and policy implications. Let me switch gears to one of the other questions that's out there right now, which is directly for Colonel Holman in Canada. And one of the questions being asked is, has Canada's combined forces defense structure had any impact on Canadian space policies? This kind of sort of shows us where we are in that development of policies as we're seeing kind of changes in the space domain.
So in some ways, that's hard to judge. Thank you for the question. But I'd point out that we have been a single unified force since 1969, and so I was 2 years old then, so I have no recollection of the pre-joint era. The one thing I can say, though, I think in comparison with some of our allies, is the fact that we have been, and all of us that are in the force now have grown up in a joint environment, has made it easier, both in the old 3-domain days, to work jointly, and I think has made it easier to adjust to the more modern pan-domain, multi-domain operational environment. The other thing I would say is that from a legal advisory perspective, the fact that we are a single organization made up of people who wear 3 different kinds of uniforms has meant that we have been less siloed, and with great respect, maybe a little less territorial, perhaps, in the way that we approach legal questions, right? So, in my time as the DJAG for operational law, the people that worked space law for me didn't all wear Air Force uniforms, right? So some of them wore Navy uniforms. We've had people who wear Army uniforms who have worked to provide advice in that area. I think Nathan would say the same with respect to New Zealand, where they've got a similar sort of structure to us. That said, the operational side of space in the Canadian Armed Forces has been given as a responsibility to the Royal Canadian Air Force. And so the force generation aspects of that are done through the Air Force, and the force employer is, up until now, has been Air Force throughout. I think that there are good reasons for that, just from a development of talent perspective. We have a very small space operation right now, really certainly compared to the United States, but also compared to the UK and to Australia. And so whether we begin to take a more joint approach in terms of uniforms, will remain to be seen. Sorry, I should correct one misimpression that I probably left when I say that responsibility for force generation in space is that of the Royal Canadian Air Force. The Royal Canadian Air Force is a command, not an actual force. It's what we used to call, the functional air command and we've reinstated for historical reasons the term Royal Canadian Air Force. But somebody wearing an Army uniform or a Navy uniform working in an operational air wing in Canada or in a space organization is actually a member of the Royal Canadian Air Force, regardless of the color of uniform that they wear. Thanks.
That's good insight. As this panel also includes coalition space operations, as we talk about the cross service, cross domain, I wanted to ask the panels another question specifically about operating as a coalition. I mean, we've done this in countless operations throughout recent history, and certainly in other domains. But now, as we see this space domain develop, in 2019, NATO announced space as an operational domain. In 2020, NATO established a space center, NATO Space Center. This year, the UK officially stood up their Space Operations Command. We're seeing all these kinds of developments with the space command and for operations to take on maybe a new role in our coalition operations. And so I wanted to ask the panel from their perspective, how your nations see this space operations fitting within the NATO model, currently under consideration, and what legal implications you may see space operations as part of NATO, or for a non-NATO panelist for that matter, how we work together, what complications, maybe what challenges, maybe what benefits we might have with space from a legal perspective in as we provide support to the warfighter of tomorrow.
Thanks, Lynn. Shall I get us started?
Please.
I'd probably reiterate one of the points I made earlier about I think it's important not to treat space in isolation, but keep in mind how it fits with the bigger picture. It's becoming more and more important operationally, but it is part of a bigger picture. And obviously, as you say, we've been working in coalition environments for many years, and we've developed ways and means of operating together that enable each partner state to act in a way in which it's comfortable, and that's legally and as a matter of policy. So I think we've got a lot of lessons learned from that and approaches we can apply to space. So I think we've got a really good starting point, particularly as we're trying to integrate space operations into everything we do. It's not seen as necessarily an entirely standalone piece. It's part of that bigger picture. In terms of legal issues, I think the ones that are common to other areas of operating in partnerships. We'll have questions about the basis for using force collectively. We'll be thinking about state responsibility and information sharing, and obviously how we govern the conduct of military operations when we get into conflict and rules of engagement, and how our different national perspectives on things need to be accounted for when we're working alongside partners. But that's something we're very familiar with and used to doing elsewhere. So there may be aspects that are more or less important to space components, but like any other operational planning, our approach can be tailored. So keeping in mind space operations are likely to be part of broader activity across other domains, I'd expect we would have a suitable overarching governance. It's just getting our heads around any space specific bits that we need to make sure are reflected appropriately. Thanks.
Yeah, perfect. Over to Colonel Holman, if you have any comments.
Sure, I'll talk in the broader coalition context, perhaps, since I'm less familiar with recent activities in respect of NATO. But I think that a lot of the challenges are ones that any of us who have deployed in a coalition or allied environment or worked in that environment on any sort of operation are familiar with. How do you translate a series of different states' perspectives on political, legal, moral aspects of particular questions into a sufficiently common understanding and common approach that allows you to benefit from the strength of that bundle of arrows or bundle of sticks that Jeremy was talking about in the introduction. how do you translate those concepts into rules of engagement? How do you, to go back to some of the discussion that we've just been having, translate some of those ideas into public messaging so that you have, the combined voices of a number of states, making statements of a normative nature in respect of, what they are doing proactively or reactively in response to another state. And it's a lot of work, but I think we're in an exciting and sort of formative time from a space perspective, where there really is an opportunity in a short period of time to make some significant advancements in building those understandings. And CISPO, for instance, is one of those entities where there's a lot of work that's been done, not just on the policy and legal side, but also on the operational side, and on the science and technology and research and development sides as well, with groups working together. I would say a couple of other things, and this is one of the challenges. When you think about a military silo or a governmental silo, perhaps in some areas, and that is security, right? And the importance of maintaining operational security, technical security, and so on, that limits, in some cases, the what can be said, where it can be said. Sometimes I've found, frankly, that one of the challenges is just finding a room where you can put people who have the proper clearances in it together and have a discussion, because you and I, Lynn, can be sitting in a public space and talking about something, and we can kind of nudge at each other and raise an eyebrow or whatever, and I might think that you understand what I'm saying when I'm talking in very vague terms, and you might be understanding something completely different from it. And multiply that by however many countries that you've got involved, and that's a challenge in getting the coalition partners on board. But then, how do you declassify that to a level where you can get other coalition partners on board, and then you can craft a broader sort of public message that might have a lawmaking character to it. I'll stop there.
Yeah, no, and I think that's a great point, because, in the work that we've done through both CISPO and Traver War Games, security classification is a constant challenge for us. One of the questions that's in the Q&A section was asking about the underlying treaties and agreements which govern 5I, and the determination of information classification, actually intelligence classification at a 5I level is an intelligence characterization of intel. And beyond the intel sharing that you have at 5I, CISPO is a 7-nation collective. And so you've got those challenges in working at that level as well. And so I find it's always an interesting discussion when you start talking about classifications and going from the various levels. But let me turn it over real quickly to Svenja and see if she has some comments she might like to add on this.
Thank you. Again, can only echo what was already said. Looking at coalitions in general, I guess we always have the same problems in every domain. We have every nation has a different threshold for actions that are happening, being it hostile act, hostile intent, and armed attack. I had this discussion so often, not only in the space domain, but in every other domain, we have those discussions. What are we understanding by those terms? And every nation has another understanding of that. But I guess in every coalition, and very prominently in NATO, we found workarounds to work together and to, although we have different thresholds, to work together and not break the coalition by it. So I guess in space, if we are going into that closed room, discussing it, we will find workarounds in every coalition we go into, might it be NATO or CISPO. We just need those discussions. And again, like already said, security classification is a problem. And we try to find solutions and we're really good at that, but it is a problem. So just saying, I guess that's what we always said. We need interpretation for already. We still need interpretation for space law, and we all will have different interpretations, and we just need to get together. Everyone says what he understands around a certain topic. What is an armed attack for every state, and then find workarounds for that. And that's what coalition is very helpful, and how coalition work in every domain. And on the other hand, for me, coalition, or for Germany, being part of coalitions, especially CISPO, but also NATO, and taking that into to our space and taking it back home is always very good to fuel discussions within or with our leaders, because then they could see, oh, that's the problem, and that's why it's important. So those discussions are very helpful for us at home, to raise awareness about space and to define our own policies.
Yeah, I think that's a true statement. I mean, like you said, coalitions always find workarounds for the definition of terms and understanding. And sometimes our biggest challenges are even recognizing that we're not talking about the same thing. To Colonel Holman's point earlier, is he may nudge me and he may think I know what he's talking about, but in reality, it comes down to the very specific definition of a particular term or its use in context, and understanding as lawyers and how we look at various provisions. Certainly from a U.S. perspective, our understanding and interpretation of use of force in armed conflict under the UN Charter is not exactly the same as our partner nations when we go into conflict. And we've resolved this in other domains, and we'll resolve it again in space, even though we may not necessarily at this point know exactly what a hostile intent or hostile act may typically look like in space. I mean, like in other domains that's been developed, like in cyber, we're starting to look at those kinds of questions. So let me turn it over to my non-NATO colleagues and see if there's any comments that Nathan, that you might want to make as far as working in a coalition environment, and how that might, some of the legal challenges in space may contribute or kind of hinder that.
Thanks, Lynn. I think I would echo pretty much what you just said. I'll leave aside specifics around NATO or UK Space Command. There are, of course, issues that would be specific to space, but I think there's a lot there, especially in a principle-based approach for across all domains and all operations that are not dissimilar. I would start again with the OST provides the international legal framework for combined space operations, but what's really needed is a shared understanding and agreement on how we apply and operationalize those principles. And just like you've said, a shared understanding would be required between states, at least in principle, to what constitutes irresponsible behaviors, responsible behaviors, demonstrations of hostile intent, or even aggression and armed attack, because this will determine what response options are available to our commanders in law, and also noting that those responses may occur across different domains for an act that occurs in space. And so, yeah, what's really required is clarity on legal implications and how we interpret behaviours and then turn that into advice. One of the steps efforts that's occurring right now, and then I can speak a little bit to, is the United Kingdom's efforts leading a resolution to the UN General Assembly. New Zealand is quite excited about this, and they're looking forward to contributing views and to the Secretary General's call for submissions. And of course, that does tie in with some of the other work that's done around CSPO. One issue I do foresee in trying to develop shared understandings across coalitions is how do we navigate the different or divergent approaches that may result from each different nation having a history of significant investment in space capabilities or dependency on space capabilities over the last 50 years, as compared to other coalition nations that have emerging capabilities or just an emerging space in this industry that perhaps is not geared up to the military. It is very much orientated towards the civil sector, because I think where decisions around space are made at the highest levels of government, they're strategic decisions. I really suspect that this history is going to be an inescapable part of the calculus. And so in addition to how do we come to shared understandings around interpreting hostile intent, hostile act, how do we navigate the different lens that we come to the party with? And to wrap that up, all I really can offer is that we should go back and be grounded in the existing legal framework, and that's the OST and the UN Charter, and I'll leave it at that.
You know what? Perfect kind of segue into some of the, or I guess kind of follow up for some of the things that we've been talking about. But I think the perspective, as you're commenting there, I'm listening to you, Nathan, as you're talking about, one of the important things here is kind of looking at the different coalition partners and what they bring to the table, and that level of whether or not it's a military capability, it could be a commercial capability, could be a launch capability. And we have to look at it with a lot of different perspectives. And like you said, there's a different lens. And so I think that makes it a lot broader than just a military question. But before I get off this topic, let me just throw it over to Craig to see if you've got any comments that you might want to add on the kind of broader coalition context, not necessarily from a NATO perspective.
Just a few comments from me, drawing on some of the July 2020 ministerial releases made in Australia to accompany our Defence Strategic Update and the Force Structure Plan. In those documents, there were announcements made about increasing sovereign capacity in terms of satellite communications and overhead imagery and different space control investments. All of those investments and comments are made in the context of a clear intent to deepen cooperation and to strengthen partnerships with allies, both in respect of activities that might be undertaken during armed conflict, but also prior to that. And I think prior to that, some of the foundational issues have been alluded to already, but from an Australian perspective, obviously we host a number of joint and US facilities as well. So that raises different considerations of sovereignty and policy matters regarding full knowledge and concurrence. In terms of networked activities and data sharing, those things also arise in relation to state responsibility implications and so on. So all of the usual issues in armed conflict are going to apply in space in terms of trying to figure out where our various delegations might sit, where our various constraints and limitations might exist from a domestic law point of view or a policy point of view. But to the more direct point about restructuring space activities, Australia has recently commenced a dedicated Operation JARA, which integrates all of our space capabilities in under one operation itself, and that's the vehicle through which But we also participate in the US-led Operation Olympic Defender, and that's across the competition sort of spectrum. So from my perspective, the important point there is to say the coalition activities and coalition operations in space ought to be normalised and thought of as normal, just as much as it is normal for Australia to contribute maritime surveillance aircraft, to sanctions enforcement over flight in the Pacific, or to participate in the quadrilateral security dialogue with India and the US and Japan, looking at freedom and activities in the Indo-Pacific. Those examples apply both outside of conflict and to coalition activities during conflict. So I think normalising that conversation around working together, contributing what we can in manners that our governments permit us to, whether that's restricted based on different sovereign interpretations of circumstances that are unfolding and limits imposed on use of force, for instance, or if they're capability related. The strength that comes through coalitions is critical, and but also the legitimacy that comes through those shared endeavours and collective security in the space domain is equally as important as it is for more conventional activities.
Yeah, agreed. And as you know, that the U.S. through our CSPOC, our Combined Space Operations Center, we've had international partners located at Vandenberg for quite some time as exchange officers, both from Australia, Canada, and the UK. And it's certainly an indication of the strength of our coalition, with a small C coalition group of spacefaring nations, and the activities that we take in our coordination. Which kind of brings me to my last question, which is sort of back to Tom Gregory, who started us off on this, and was back to Tom on his the stand-up of the UK Space Operations Command. I mean, similar to certainly for the US and the stand-up of US Space Command, we've now had a year or so under our belt to try to mature this command, and it's sort of a rebranding of what once was a U.S. Space Command, but in a totally new and different environment, I would say. So over to you, Tom, to see what are some of the things that you see with the UK Space Command and the stand up and the role of that organization.
Thanks, Lynn. Well, it's obviously an exciting time for us as we're sort of embarking on new adventures. And Space Command for us is to bring together space operations, space workforce training and growth, and space capability in one place. And it works alongside our also recently formed Space Directorate in Ministry of Defence, which is responsible for policy, strategy, and cross-governmental and international engagement. So we've got there's the kind of operational, more detailed stuff in Space Command with our kind of strategic partnership coordination in the Space Directorate, and seeing those two work together is, I think, going to be fascinating over the next few months. I mean, it's a relatively small community which we're growing, so there's a lot of familiar faces involved, and as we all know, in our kind of group of nations, we do come across the same people in different roles over time. But I think we will see it expand quite rapidly over the next few years. And for people who aren't even directly involved in, say, the Space Directorate or Space Command, they'll become far more aware of space and its role in military operations, and it will raise a lot of awareness. So I'm looking forward to that. Yeah,
it's actually a very exciting time, and I want to thank all the panelists for their contribution today, and for some of you, some less than optimal time of day for you to join us, but we really appreciate your insight and your comments. I've been watching the Q&A session, and I think we've kind of like weaned down a little bit, as the East Coast is kind of calling it an end of day for them, and we're slowing down here on some of those questions. But I wanted to, before I hand it back to Jeffrey, Biller and USAFA folks to wrap us up. I just wanted to allow a real quick opportunity for anybody on the panel to provide in any final comments, if you would, before we close. Shall I just go in order then? Let me start with Tom Gregory. Let you just do a real quick.
Thanks, Lynn. I just say it's been great to be part of this. We've heard how much complexity there is with space, so it's obviously important to be alive to the areas where further thinking or new developments might be helpful. But it's probably no surprise, given my earlier comments, that I just encourage legal advisors to keep in mind the full suite of legal tools we already have and make sure we're using them as best we can. And I think that way we can better understand where we're in a good position and where we're in a less good position, and take it from there. So thanks very much.
Great, thank you. Colonel Holman, any comments from you as we close?
Yeah, thanks, Lynn, and thanks to all of my fellow panelists. I think the only additional thought that's popped into my mind as we've sort of wrapped up the discussion is that your last question referred to support to warfighters, and my reaction there is that we need to recognize that the warfighters are not necessarily going to be fighting wars. And one of the challenges that I've certainly experienced, and I think some of my colleagues have as well, that I think is worth describing, is in the emerging domains, and certainly in cyber and in space, the operators that we advise don't have the same nice linear framework for reasoning that exists in the domains that we all grew up in, if that makes any sense, right? So, if you think about, okay, am I in an armed conflict? If I am in an armed conflict, is what I'm about to do an attack? If it is, well, then I know exactly a nice process to go through my targeting reasoning. But if you're not in an armed conflict, or if you are in an armed conflict and what you were going to do is not an attack, you don't have that easy to sort of walk through checklist. You're then into this area where there's really a constellation of legal frameworks that may or may not apply. And to wrap it up with the discussion that we've just had, for the legal advisors, understanding each other's and each other's states' views of how, what does apply in that constellation and how it applies is hard work. And in these emerging domains, it's work that it's really important that we take seriously and that we take the time to do. And that's, I guess, my last point about where things like CSPO and the Shriever War Game are enormously helpful, because it puts us in venues where we can actually sit down and put aside everything else and have those discussions about, what does self-defense mean to you? What is a hostile act? How do you use that in your doctrine? And so, it's a pitch as from Tom, that we keep talking and we keep working together in order to ensure that we have as clear a set of shared understandings as possible.
Perfect. Thank you very much. I appreciate that. And over to Captain O'Brien, if you have some final comments.
Thanks, Lynn. I guess the only final comment I have is just a very big thank you to yourself, to the panelists. I've learned an immense amount just listening to everyone else, and I think that dialogue is the cornerstone to the pathway towards shared understanding. So I look forward to hopefully continuing the conversation elsewhere, perhaps in other conferences or in CSPO, or hopefully one day even in person, perhaps. But I'll just finish with that. A big thank you very much.
Thank you, Nathan. I appreciate that. Over to Svenja for any final comments you might have.
Thank you very much for that discussion. It was really interesting, and I enjoyed it, although it's very, very late already in Germany. I'm very much looking forward where we will be in a couple of years. When I started in space and military operations in space, we were really very much at the beginning of understanding how space law and military operations work, and now looking at all those space commands popping up around the nations. I'm really looking forward how that will come out in a couple of years from now, and how our understanding of space law and the Outer Space Treaty and military space operations will look like then. So that conference is a really good starting point to broaden our understanding even more.
It is. Thank you very much, Svenja, and thank you for being part of that. And last but certainly not least, over to Craig for any comments that you might have.
Lynn, thanks. I think I'd just reflect probably the manner in which you opened the panel to comment that it's been quite a long time since we've all been able to be together as colleagues and friends, whether in war game or other scenarios. I thoroughly enjoyed the discussions. I hope that the audience and participants have as well. I look forward to catching up with each and every one of you when we're next able to travel and get together again. Cheers.
I agree and echo that comment. It's certainly a wonderful opportunity for so many people to be able to participate in something like this. Certainly the inaugural U.S. Space Command Space Law Conference. It's a tribute to, actually, I think all of you in what you bring to this discussion as panelists, as space law practitioners, but that we have still 164 participants on the net right now as we're getting close to the end of day. So thank you all for your comments and your insight, and I share with you the excitement and enthusiasm for the next few years as we continue to explore space law, space operations, and where we go from an international and coalition perspective. And at this point, I'm going to turn it back over to Jeff Biller.
Great. Thank you so much, Lynn. And thank you to our partners in space. It really is vital to understand the legal and policy position of our partner nations in the space enterprise, as in other areas of military operations. And you guys just really did a fantastic job of exploring those issues.